Hi, welcome back to another episode of Retirement Roadmap. We're glad you're joining us again today. We have a great topic and a great guest for today. We actually have Sarah White with us today. Sarah is one of our lead practicing attorneys that do a lot of our estate planning for us and for our clients. So we're really delighted to have her. You want to say a little something about yourself?
Sure, thanks for having me. I have been doing estate planning for about 22 years. I practice in Marietta. I also work a little bit in Woodstock. I love estate planning. I do tons of wills, tons of trusts, a few adult guardianships. And in my limited free time, I have a husband and 4 daughters and a lot of pets.
Oh, that's more than I think I knew before. So I'm glad you shared that. That's really good. So we're not going to get real deep in the weeds today. It's we have a short amount of time to talk, but certainly want to kind of get a feel. We've talked on a show before, just Evan and I, about what is a will, what is a trust. So I don't know that we need to get into the deep definitions, but maybe just a brief overview of the main documents somebody should have.
So there are a lot of main documents, or several important main documents somebody should have. The 3 that really pretty much everybody needs are a will, a power of attorney, and a healthcare directive. Now that is in Georgia. It varies state by state. The will is going to, obviously, most people know, it tells where your assets go when you pass away, tells who your executor is. The power of attorney gives someone, whoever you name, permission to do financial things for you while you're alive. And so it's designed for incapacity or maybe out of the country or something like that. And then the healthcare directive deals with naming somebody to make healthcare decisions for you if you can't for yourself. And then it also breaks down your wishes on things like that. A lot of people would also benefit from a trust, several different types of trust, but maybe a revocable trust. But not everyone needs a trust.
So let's talk about that for a minute. So we've heard about living trust, revocable living trust, which is I think what you're referring to. What are the pros and cons between using that and just a standard will?
So there are definitely pros and cons between the two. A will generally, so they're both designed to handle assets after you pass away. The will generally is simpler to draft usually because you're just saying, hey, this is where my stuff goes when I pass away and this is who's in charge. So that's pretty easy. It's usually a little cheaper. The downside of wills, few downsides, they do become public record when you pass away. There usually is not a ton of confidential information in a will, but just know it does become public record, and a lot of people don't like that.
You actually have to publish it, don't you?
You do publish it.
Kind of let people know, hey, I'm gone, come get it.
Yes, yes. It is, some counties have them available online, so you can look at anybody whose will who passed away when it was filed. A trust generally is designed to hold assets while you're alive, so when you set up a trust, you put a lot of stuff into it now, and then it can help because when you pass away, anything that's in that trust does not go through probate. So I did not mention a second ago, when somebody passes away and there are assets that have to pass under the will has to get probated. That can be easy or that can be a hellish nightmare, depending on the situation. So trust, anything inside the trust does avoid probate when you die, so it can help with that. Generally, kind of the downsides of trusts are they're more work to set up, they're generally more expensive, and sometimes people will forget to put the assets into the trust like they're supposed to, so then they get to do the trust and they do probate. So kind of something to be aware of.
Which is one of the things we do in coordinating with Sarah and our estate planning attorneys is we actually, along with your help, make sure everything they have or everything that we legally can put into the trust gets put in there, as opposed to, I've seen some estate plans, they come in and it just has an instruction sheet.
Yes.
And the people never get around to putting their house in the trust or whatever else might need to go in there. And so it's just a very expensive book.
Pretty much, yes.
At that point. So why is it important to avoid probate? Now, you said it's a public. Are there costs avoided with probate?
There are costs. So generally in Georgia, so some states have just astronomical costs to the court.
I've heard Florida.
Yes.
Yeah.
I don't know Florida's off the top of my head, but I've heard they're based on the value of the assets. Mm-hmm. And Georgia's, it's a set fee, it's reasonable, but usually you need an attorney to help. And the attorneys, the more help you need, the more expensive it is. So it just kind of depends on the situation. But generally, yes, there are costs involved.
I've had so many people come to me, and attorneys and non-attorneys. Typically, the attorneys that come to me are not estate planning attorneys. They're kind of a general practitioner. But I've heard this phrase so many times probate is no big deal in Georgia. And it makes me wonder, I kiddingly call this the attorney 401k, because the will's cheap to put together, but the probate can be expensive on the back end, and then they keep a copy. And I'm just wondering, is there something else going on there? But I think probate has gotten more difficult from what I'm hearing here in Georgia.
They did something recently to make it a little more difficult. I would say generally, other than which I won't get into the weeds, the small change to make it a little more difficult last year, I would say they haven't done a lot to make it more difficult.
Okay. So biggest thing I'm hearing is a little more expensive on the front end, but maybe more expensive on the back end. I've also heard, though, that a trust is difficult to contest, but a will can be contested pretty easily?
So they can both be contested, but it is harder to challenge a trust than a will, generally.
Okay. Especially the older it gets, I think. Yes. I've heard that as well, yeah. We actually have a client that is last stages of battling for her life, and so we went back in and made sure everything was right, and we didn't want to redo the trust because it was like an 8-year-old trust, very difficult, we thought, to contest. So it's I learned something new every time I go through one of these from you guys, because you guys were so knowledgeable. But so what are the we've talked about a living trust. What's the difference between a living trust and an irrevocable trust?
So they are two kind of completely different things. They're both types of trusts. A living trust is also a revocable trust, or revocable trust. They're the same word. A living trust generally is designed to avoid probate, and it is designed to make things easier. And it also, I didn't mention this earlier, but it can have some advantages if someone becomes incapacitated with assets in the trust. So that's pretty much the purpose of the living or revocable trust. The irrevocable trust is a trust that the person setting it up does not change and does not control, generally. There's exceptions to everything I'm telling you, there's exceptions to, but generally they don't change it, they don't control it. And the big goal of that usually is protection from creditors' claims. So that's either typically somebody in a high-risk occupation, maybe, or they're just worried about creditors taking what they've got. So they put.
What about avoiding long-term care?
Yes, that's the second big reason that people do those. Is you put your the thinking is you put your assets in one of those trusts. You wait 5 years. You go into a nursing home after that. You can qualify for Medicaid, and Medicaid generally, that trust kind of protects those assets from Medicaid.
So they can't go after your passing or whatever. Yes. Okay. And then the third positive I've heard with a trust, an irrevocable trust, is not a big problem right now, but is the death tax. If you've got over right now, it's 11 point something million or 13 million, I believe, has to be in your name before anything's taxable at your passing. But that's due to regress back to like 5.6 million January 1st of 2026, when the 2017 tax cuts expire. And so now you're looking at 5 million. Anything you own over 5 million at passing is taxed, I think it's between 30 and 50%. So we also discuss with clients that are higher net worth clients about how do we get that out of your estate. Well, an irrevocable trust is also a very good way of doing that. And again, maybe even have a life insurance policy that's owned by the irrevocable trust, so that the death benefit that pays out that helps pay the tax doesn't become part of the estate. So it's a little more complicated, probably deeper than we wanted to go today. But I think those are three great reasons to consider an irrevocable trust.
Yes, and those irrevocable life insurance trusts were very common a few years ago. And since they've raised the estate tax exemption so high, personally, I don't do as many of those anymore, but I could see them coming back into fashion soon.
Well, and there's been talk, it's going, like I said, it's going to drop back down to 5.5 million or so per person, but there's talk in committee of maybe dropping it down to 3 million. So if that happens, you can start doing more of those.
Yes.
Absolutely, absolutely. So while we're on the subject of trust, I've heard this term and I've seen it actually happen in my life and in others' lives when it has been fixed appropriately, and that is something called disinheriting someone or disinheriting your children, either by accident or on purpose, and I'm sure it can happen either way. What does that mean?
So it means either a child or a stepchild of yours is for some reason not getting inheritance from you, and of course it's often intentional, but it can be accidental, and it can happen when you have outdated estate documents, or maybe kind of commonly, I guess, would be maybe a husband and wife they have a very happily blended family. They each have kids of their own. And, one of them passes, everything goes typically maybe to the surviving spouse. And maybe that surviving spouse, when they were together, they wrote a will that says everything to my children, all of my blended children. And then that surviving spouse, either that will, something happens to it, or maybe the will goes missing, and then or the person gets dementia and maybe can't fix anything. And so then if we don't have a valid will or a trust, the assets pass under state law, which state law does not say stepchildren get anything. And so a trust would be a good way to avoid that. Put the assets in the trust. Doesn't matter what happens after that because the assets are in the trust, and they'll go to all the blended children.
Yeah, we've seen it happen again. People have come in and told us the story of their parents or grandparents or whatever, and see it happen a lot in a second marriage. Which unfortunately happens a lot nowadays as well. So it's certainly something else to be aware of, which is why we only use estate planning attorneys that understand these concepts for sure. So by the way, we have a resources tab on our website, masterplanretire.com. That resources tab has all kinds of publications and checklists, including a legacy planning checklist. Certainly go to that, masterplanretire.com. It's also where we put up our classes, upcoming classes, federal classes about federal benefits, Social Security planning, income planning, tax planning, all of that type of thing. And by the way, we do offer a complimentary consultation. Lots of folks hear our show, see our show. They're like, hey, I need to talk to these guys. So 770-980-9262 is the number. And also on that website, it has a little button. It says, schedule an appointment. You push that button, my calendar pops up. I'm the lead advisor here. And you're able to get right on the calendar. Complimentary discussion, chat about your situation, your concerns, your dreams, your goals, your oh no type of things too. So masterplanretire.com, I hope you'll take a moment and visit that. So let's get back into a few other things here. What are some of the misconceptions about estate planning? I know a lot of folks will come in and just say, hey, I've got a document, but I picture that document needs to kind of wrap into the rest of their financial world as well. So that's maybe one misconception. Anything else come to mind that?
Yes, I see a lot of I hear misconceptions every week. So one I hear is it has to be very expensive and has to be very difficult. Neither of those things has to be true. It can be fairly easy. I mean, we do have complicated situations occasionally, but it can be fairly easy to get documents done, and it does not have to cost a fortune to get some estate planning done. I also see the assumption, well, if I did it once, I'd never have to update it again, which is definitely.
When was your will written? 1942. Oh, we might want to look at that again.
Yes, I see those all the time. I've probated some wills that were written before I was born, so that's not ideal. I've also seen assumptions even that people have the documents. Like, I don't know how many times I've heard, Mom has her documents. I am her power of attorney. Well, do you have a copy of it? No.
Yeah, where's
it? It doesn't exist anywhere if you don't have it. So.
Yeah. Well, something else that brings me back to think about that for just a minute. So many people put their documents in a safety deposit box. Now, my understanding, it also happened again in our family, is one of the first things that can happen is that box gets sealed.
Yes.
So now your will is sealed and can't be opened until probate, right?
Until there's a court order from a probate judge,
okay.
Yes.
But also, if you keep your health care directive in there, when do most accidents happen?
Not while the bank's open.
That's right, exactly. So, get a nice fireproof box, a safe or something, keep them there. Maybe make sure that the people that are in it maybe have a copy of it and things like that as well. So not trying to give advice instead of you.
I agree with everything you just said. So.
Just things that pop into my mind for sure. So, so what about as we kind of shift into the knowledge base of using a regular attorney versus somebody that understands and studied estate planning? What about folks that go online and do the online type of will?
So I have a lot of people ask me about that. I usually tell people, now obviously I have a vested interest in people not doing documents online, so keep that in mind, but I see a lot of people who have the documents that they've done online, and I don't know how many I've seen, but I only saw one that they looked great. And I told them they look great. Most of the time what I see is Not necessarily that there's much wrong with the software, but it doesn't give you much guidance if it's anything other than a very cookie cutter situation, which most people, even people that think they have cookie cutter situations, there's usually some variations. They really can't give you advice or guidance. And even just like the practical, there's a few documents that need to be filled out and initialed and choices. And if you don't have any guidance on that, I think it can be tricky to do. And even just the signing logistics, like in Georgia, to have a valid will, you need 2 witnesses and a notary. If you knew how many wills I saw that people had done where the notary's one of the witnesses, or they did them but they never signed them because it was hard to find somewhere to sign them. So just a lot of little things like that.
Yeah, yeah. And we see the same thing. They come in here, and I was also told, again, I've kind of helped a client or two go through probate, very simple probates, right, just to give them some guidance. But my understanding is that the will actually has to be okayed by the probate court.
Yes.
They got to go through it and make sure everything's done properly, or they can throw it out and you're died without a will.
Yes, there's a lot of things they look for. Is it an original? Does the date match up with the date that the witness has signed? A lot of reasons it could be tossed.
Yeah, and then it's kind of too late.
Yes, it's definitely too late at that point.
Same thing with your financial power of attorney. And I know now there's new language about electronic and passwords and things like that. What is that about?
So in 2017, Georgia passed a new power of attorney law, which I'm a fan of. We have a pretty standard power of attorney form to use in Georgia now, and it does actually deal with some digital assets. And digital assets can be a bit of a pain to deal with after somebody passes. So we're trying to make it a little easier if somebody's incapacitated or they pass away to have some language that helps deal with those digital assets. So it's a start.
I had a friend, she lost her son, and she could not get into Facebook or get Facebook to, take him off or change, or her to be able to put stuff on there. And that's just one little site, one little thing. Imagine how many places people go online now. I mean, our whole financial world operates online.
A lot of sites like Facebook are starting to have legacy. You can name a legacy account owner, I think it's called. And so we're trying to catch up, but it's still difficult.
Yeah, very much so. What would you say to somebody? I've had people tell me this, say, I don't really need a will because my wife and I own our house jointly. I'm her beneficiary, she's my beneficiary, so we pretty much got everything covered, we're cool.
I hear that a lot, and there's so many things wrong with that. Often the house deed may say that you two both own it, but it may not say anything about survivorship, so it doesn't mean that your half goes automatically to your spouse. It often doesn't say that. You may think you have joint owners, beneficiaries on everything. Maybe you don't. Maybe you do have, maybe everything's set up 100% correct. What if you two pass together? Also, what if maybe the reason you pass is a doctor committed medical malpractice? Well, that is a claim of your estate. The will is going to tell where those funds go if there was a judgment. So just a lot of reasons. Even if you have a very simple married, one kid together situation, you still need a will.
Had someone come in, it's been 3 or 4 years ago, and they'd gone to a class, I think at a church. It was a class, I'm not sure if the connection, but about doing a trust. And so this company obviously made their money doing trust. And I said, well, let's review the trust. It was 4 pages long.
Oh.
You can't have an opening paragraph with four
I think my shortest trust is about 13 or 14 pages long.
Which is still really short,
Yeah.
by the way. But it certainly tells you that there's a lot of people out there trying to make money off of this type of thing that really either they don't know what they're doing or they don't care what they're doing. And there's a lot of that out there, which is one of the reasons I think that we have a good partnership with Sarah here is because we know the financial picture, Sarah knows the legal picture, and we kind of marry those together. And so it's a complete look as opposed to going into an attorney, even an estate planning attorney, and say, I want a will. Well, you know what you get? You get a will, unless you say, what should I get, right?
Yes.
And without looking at deeds, how's your deed? Just like you said, beneficiaries, how do they line up? Maybe your beneficiary says this kid and your will says this kid. Well, the beneficiary takes precedence. And so now maybe the wishes don't get done correctly or whatever. So now I've also seen stories of people not trusting their documents. So they'll go in, and let's say somebody's got a terminal illness, and the will says all this stuff, and they say, well, let's make sure it happens. I'm going to go ahead and put the house in your name, or the rental property in your name. And now there's a tax situation on top of some other things as well. So I call that, I've got to be careful of the wording I use. I call that lazy person planning or something like that. I used to call it something else. I won't say that. But it's a way of trying to save money, or maybe a panic situation or whatever, and suddenly what you wanted to happen is not going to happen, unfortunately. So we see that a good bit as well. But do you see a positive in working with a planner in putting together documents and a plan like
Yes,
that?
very much. I love it when my clients have professionals like yourself that they're working with, and it's just a lot of reasons. One is if I give them instructions on beneficiaries, then I feel more confident that they'll actually follow up, or I can coordinate with the professional. Also, I just like kind of the ease of. Sometimes my clients are confused about what kind of assets they have. So we can call the professional and say, is this an IRA, or is this a brokerage account, or is this an annuity? What is it? So I just feel like there is a very valuable partnership there.
Yeah, that's one of the first things we do with a new client, even a prospect, is we organize their stuff. We set up a financial statement, which of course we have permission to send to Sarah for the client, so that she, exactly what they own, how it's owned, how's it titled, all of that, and then what changes we need to make at that point. So I think it is a powerful combination, and that's why I think it's important to use a retirement planner that does do holistic approach, that we are working with tax planners and tax attorneys and estate planning attorneys and things of that nature. Maybe they want to set up an LLC, so we want a business attorney to step in and handle some of that type of thing. So it's this whole one-stop, I hate to use the word shopping, but one-stop shopping, so that, again, there's no holes, there's no potholes, there's no dangers that get missed, for sure. So we are getting a little short of time. Anything you feel like you can add to the discussion to kind of wrap it up?
Yeah, I would say, in addition to just doing documents, working with somebody like Mark, or just making a list of passwords, assets, beneficiaries, things like that. It's often just as important as they're doing the documents themselves, knowing where the things are, telling your kids and anybody else you've named in your documents that they have a role in your documents. You're my healthcare person, you're my executor. Telling them where they are and letting them be able to get their hands on the documents is crucial. Yeah. Sounds simple, but it seems like that's half the battle sometimes.
Well, and really one of the last meetings we do when a client becomes a full-fledged client is we try to have a family meeting with the permission of the parents, but bring the kids in, the beneficiaries, whoever else is involved, the executor or whatever, and sharing with them what the client wants to share. We don't tell them everything, but making sure they understand, the first place to go financially would be call Master Plan, because we know where everything's at, we know how it's set up, but also just us to be able to meet the family, the executive we may be working with down the road and things like that. So I think it's a really important meeting we have. So we really appreciate you being here today.
My pleasure.
Treasure trove. I always learn something when we have a great guest. So that's happened again today. A couple of things here as we wrap up. Remember the website, masterplanretire.com. You can schedule an appointment there. You can sign up for a class. You can just look at the other resources we have. Just a treasure trove. Bookmark it. Go back there, you'll need it again. Something will happen, something will trigger, you'll want to retire, you'll get laid off or something, hopefully not. Masterplanretire.com, and also the phone 770-980-9262. And come see me, let's do a complimentary consultation and see where you're at, okay? Until next time, take care. This was Retirement Roadmap Radio with Mark Fricks of Master Plan Retirement Consultants. To schedule a complimentary consultation, go to masterplanretire.com or call 770-980-9262. Thanks for listening, and remember, plan well and prosper.
All matters discussed during the show are for informational purposes only. Each individual situation may vary, and the opinions expressed here may not apply to everyone. Materials presented are believed to be from reliable sources, and no representations can be made as to its accuracy. All ideas and information should be discussed in detail with one of our qualified representatives prior to implementation. Advisory services offered through Master Plan Retirement Consultants, a registered investment advisor in the state of Georgia. Mark Fricks and Master Plan Retirement Consultants are not affiliated with or endorsed by the Social Security Administration or any other government agency.